Good morning, everyone. Good afternoon, everyone.
Afternoon, Your Honor.
So I have a little bit of a conflict in that I think that some of the judges thought, and I thought this was going to start at 12:10. I see in the bar news it was advertised at beginning at 12 o'clock. So I think we'll try to go ahead and get started, and then we can share information with people as they come in, or if there's some difficulty. This is being likewise streamed on YouTube and recorded so that we can utilize it as an tool for everyone moving forward as well. First of all, I want to thank everyone for being here. I have no cute way of introducing this meeting. We are trying to do our best to communicate with everyone and cut off what I would suggest is a rumor mill that can never be cut off or stopped, but at least we're trying to provide some opportunity for some in-stream corrections and additional information. I don't know whether or not Judge Harold Clark is going to be able to join us. I think he was going to try. I'm getting a nod yes from our court administrator. So I guess I'll just try to have some introductions. My name is Judge Tim Fennessy. I'm in Department 11. We have 6, typically 5 presently departments that are devoted to individual trial calendaring hearings, as most of you know. We also have family law judges, and that is a civil law department as well, though there are certainly special rules for family law cases. Typically, we have 3 then of those 6 that are devoted to hearing civil cases and 3 devoted to hearing criminal cases. We've attempted to do our best to address the criminal case flow as this pandemic hopefully winds down and as we begin to be able to go back to trial work and in-person trial work or in-person court presentations. I think that the bench would like to say that we have done our level best to maintain our abilities. But the biggest physical limitation that we've had over this time is that we do not have large enough spaces in the Spokane County Superior Court house to have jurors socially distanced during breakout, except for one jury room. So when we have a 13 or 14 person jury and we need a break during the morning, or they need a break while counsel argues motions or some other objection, we have nowhere to go other than other courtrooms. And so it's really been a difficult adjustment. In that process, we adopted emergency provisions with regard to discovery, with regard to staying deadlines, and we've now gone back to having discovery and relying on everyone to manage their own schedules and to bring those issues to the attention of the courts. I see Judge Harold Clark is here, so I'll just make introduction. Judge Harold Clark is our presiding judge, and he's going to report on me if I misstep to all the rest of my benchmates, and then he's also going to make sure that we're all operating on the same front. I also have Commissioner Michelle Ressa here. Commissioner Ressa is going to talk to everybody about the challenges, particularly on the civil motion docket that and other family law dockets that our commissioners are seeing, and help prepare you all for what you're going to see as you return to more active courthouse practice. And one of the things that I hate the most about Zoom is that it's a little bit directorial for the person that's trying to be the host. So I'm trying to do my best to get through this intro stuff and then leave it open for everyone's question. And then we also have Ashley Callan present. She's our court administrator, and as is true of most teams, they know how to get things done, and then we hopefully know how to do it. But we rely on her very much for getting things in proper flow. So, as we all know, we've sort of hit a stall on discovery. We hit a stall on trial work. We hit a stall on in-court procedures. And we're now trying to make sure that we provide an opportunity for the practitioners to bring these matters back and to recommence moving forward on, particularly for this forum, civil cases. Now that means that we all have to recognize that there are certain things that we used to do that we probably have changed forever. And we probably will have Zoom attendance at hearings. We'll probably have that as an option moving forward. We may or may not have options. I believe that we will forever have options for witnesses to testify. I think that we should look at that and understand it provides us an opportunity for increased access to justice, where witnesses, parties might only have to take a much shorter period of time out of their workday, out of their life, to be able to testify, and it gives us all a better window into the opportunity and to provide justice and the access for justice for our citizens. On the other hand, particularly those of us that are used to and believe mightily in our own abilities, it's going to be an adjustment time. We think that we get a better sense of whether someone's telling the truth and how to get at that truth as questioners or interrogators if we have that person present in the same room as us. And so we're going to have to work through modifying our procedures, modifying our own view of how that is accomplished moving forward. That's going to be an approach. Some of it can be managed by the bench, but much of it we need your input as practitioners so that those questions are actually highlighted for us. We have had questions about how can we recommence jury trials. The bench has made arrangements along with court administration and the Board of County Commissioners. We have a courtroom, a remote courtroom set up out at the Spokane County Fairgrounds. We have another remote courtroom down at the Convention Center. And at least presently, it looks like we're going to be able to keep those open. I can't say on 60-day windows, but maybe on 30-day windows as our society begins to reopen and those spaces are needed for their traditional uses. But right now, we can go out and select the jury in the at the fairgrounds or at the convention center. We can then seat the jury. We can then have the trial there, and we have space for the juries to be. We have space for the juries to recess or to be during motions. We have access to at least the Zoom platform. We may not have in each of those locations a big screen like we do in each of our courtrooms, but we certainly have video capabilities that counsel can take advantage of. We have internet connectivity out there. We have microphones so that everybody can be heard. We have space for our court reporters. So those are fully functional now, remote sites that we can have jury trials in addition to having jury trials in the courthouse. In the jury trials in the courthouse, we've then taken the liberty of using some courtrooms as jury breakout rooms so that we can then have more than one jury trial going in the courthouse. I think, and Judge Clark or Ms. Callan can correct me, I think we've had as many as 3 jury trials going at one time in our courthouse, which is a downward trend from where were capable before the pandemic, but it certainly is an upward trend from where we were a year ago at this time. And now, if we had 3 here, we could also have 2 remotely. We could be back to having 5 jury trials going on at any given time. So that's a positive, and we hope that we're going to be able to continue to provide that option or those options for you as we return. Many in the court are trying to make sure that we have, and those of you that haven't been in, please do come in. We have plexiglass around most of our courtrooms. We have our court reporters are protected. We have dividers at counsel table. We have social distancing so that my clerk, the witness, the court reporter are all protected. We have the courtroom all marked out for social distancing. And we're hopeful that maybe that social distancing will be modified by guidelines as we begin to reopen. We'll have more ongoing ability. As you can see on the screen, I also have my clerk's computer is set up with a Zoom camera so that you can see counsel table, both the lawyers and the podium. I'm visible when we're fully functional. I also have another camera that is set up to show the witness chair so that all parties can see the courtroom, the court, and the witness who's testifying. And then the jury can be present here in the courtroom. With social distancing, I can accommodate 14 jurors on just one side of the courtroom and still have room for the public. And again, we can continue to do the streaming thing for the public as well. My last introductory piece is that we're trying to do our best to move forward. We did get one question from our inquiry or our request. There was a question from a lawyer about how the criminal cases and particularly the Blake issues is going to, how that will impact our return to having civil jury trials. And for those of you that have that question, my answer at least is that everyone in the criminal justice system is doing their best to adjust. We know we do have a great influx of cases that will have to be resentenced, that will have to be addressed because of the Supreme Court's decision finding the possession of controlled substance statute to be unlawful. The state legislature addressed some of the issues. We're setting up some remote hearings. We're working with the prosecutor's office as well as the public defender's office to make that process of resentencing or addressing the sentencing and or vacating those convictions as smooth and as uncumbersome as we possibly can. We do have criminal rights, we have civil rights of the accused. We have to address all of those things, but we have some legislation in place. We have some funding in place. We've got some additional authority to be able to utilize commissioners in streamlining that process. And we as a bench have been addressing that for coming on a month now to make sure that we are ready to move as quickly as we can. So I don't see that as being a complete roadblock. I think it's going to be a diversion for some of our judicial resources, but I don't think it should stop, and I don't think it should be a prohibition from us moving forward. We are hopeful that you will come to us with ideas and have input. We certainly have room in our jury rooms for 6-person or 8 persons to attend and maintain social distancing. So if council can reach agreement in that regard, we can accommodate those smaller jurors. I understand that that's asking everyone to think well outside the box. but that's one of the topics that is there. I continue to maintain, at least in my department, a hope, and I'm trying to follow the schedule as we have it laid out. I'm trying to set aside criminal months for criminal cases, civil months for civil cases. And if you come to me and you're ready for a civil trial, we'll have it heard. I think that I can speak for my benchmates to say we're trying to be as innovative and as we can possibly be. I have a courtroom that is of a particular size where if there's not too many parties or too many representatives, I can have the clerk, the court reporter, and counsel in chambers. So we can be the ones that move into the chambers to have, if we need to have a sidebar, if we need to make a record outside the presence of the jury, and have the jury take their breaks in the courtroom and be able to move around and mill around. So that's one of the concepts that I throw out there. I think that if we all are innovative, we can make room and make time for these cases. I do know that some of our benchmates have thus far been continuing cases, particularly complex cases that are on their dockets and setting them out to the end. I think we're going to continue to try to work to get those cases, to get courtrooms available so that those cases can be tried and can move forward. With that, I'm going to ask Commissioner Ressa to step up, and she was going to provide us all some input with regard to the commissioner's view, particularly in our ex parte department and what you can all anticipate as you return. So Commissioner Ressa.
Thank you, Judge Fennessy, and thank you for all of you, almost 50 of you, spending your lunch hour with us today. It's a really helpful show up because we don't yet have the kind of distribution lists and way to blast out information that we've been wanting to do over the last year. So you're coming to us in this way is really helpful. I'm going to share my screen if I can find the ex parte policy. Looks like I don't have it open yet. So what you're seeing here is that we had an ex parte priority policy before COVID. It was posted outside the ex parte courtroom when it was up in 304 to help the flow, so that if you came during the time when it was your kinds of case priority, you would hopefully not have to wait as long. When we moved the ex parte courtroom to the second floor in order to have more space, because it's still the room that we have the most people attending in person, and we have no way to know how many people will come at once. We just needed more space, and that has really helped a lot for managing the flow in ex parte. However, we have different hours since COVID, and I know a lot of you have been coming in waiting a very long time. So the priority policy is back, and we have priorities now posted in the ex parte courtroom. It's posted on the court's website under court policies, and I'm showing it to you here if you haven't seen it yet, to know when would be the best time to bring your kind of case to ex parte so you don't have to wait as long. Also know that the clerk's mail-in process is still available at I believe it's a $30 fee, but that $30 can sometimes be a lot less expensive than sitting in the courtroom for a couple of hours. So I wanted to specifically look at Tuesdays and Thursdays with you, because on Tuesday mornings and Thursday mornings, the courtroom is not open to that walk-in traffic right now. And so when you come on Tuesdays and Thursday afternoons, you'll probably see a very long line at about 1:15 starting to form outside the courtroom, and a lot of chaos right at 1:30 when the courtroom opens. And as you can see on the priority policy, that we have to manage and process those emergency protection orders, restraining orders first, because all of them have to be to law enforcement by the end of the day in the system, so they will be enforceable. So it's not that we don't want to take anybody on a first come, first served basis, but on the afternoons on Tuesdays and Thursdays, signing agreed orders, signing probate, signing agreed guardianship continuances, sadly could have a very long wait. So we encourage you to come during the attorney priority time on Monday, Wednesday, and Friday mornings. So you can see at the very bottom, the 3:30 to 4 o'clock time, every day we have to leave some priority for if we have a civil warrant, contempt hearing, or need for hearing. And that will just really end the day if we have one of those hearings. It doesn't happen every day, but just, again, we want you to see that that is a possibility if you come during that time. I know some of you come at the very end of the day with a stack of agreed orders. They're simple and they're agreed. But if we're doing a hearing with a person who has been arrested, that will probably end the day. So again, it's on our website. I encourage you to follow it. It's, we're not going to not speak to you if you come in at a time that's not your priority. And of course, sometimes the courtroom is less full than others. This is the suggestion for you to think about if you're going to come over and don't want to have to wait very long. I think those of you who've been in ex-parte since COVID probably have seen the incredible amount of non-represented people that are there. The new Minor Guardianship Act is very confusing for everyone. And people are getting, well, I think people's ability to cope right now is just a lot more limited. And it's a very stressful place to be. So please be patient with us and help us be patient with you as well. So again, that's on our website if you need to get a reminder. It's also posted in ex-parte if you need a reminder. The other piece I wanted to talk about is the court orders after family law hearings. I see that to be likely the most difficult transition that still hasn't really been worked out well. So before COVID, when you were in person and you finished our family law hearing, the lawyers would typically go out into the hall or stay in the courtroom if there wasn't another proceeding, figure out the order, get it signed. If there was a question, the court was right there to answer it for you. Well, now the next Zoom hearing has already started and there isn't really that opportunity. And they aren't coming in as fast as we would like them to. After a few weeks, I will not have remembered likely what happened at the hearing. And so then a transcript will be needed and an extra expense, or even potentially a presentment. So we're asking that as soon as you possibly can after the hearing, have an order ready. I would ask that you act the same as you did when you were here about getting an order done, and know that you're very busy people and that once your hearing is over, that you're setting aside some time with the other counsel of getting an order done. You can also propose an order before the hearing if it's the type of hearing that could accommodate that. So then it's already there for the court to see. Lots of different groups, the National Center of State Courts, even our Family Wizard group are doing studies on remote hearings and how they're working and what's not working. And as Judge Fennessy said, courts are going to have to decide whether it's at a Supreme Court level or a local level of whether Zoom will be allowed or remote hearings will be allowed. And a couple of things that I've seen in the research recently, I wanted to bring up quickly today. And these are two of them. Preparing your clients ahead of time for what a remote hearing will look like. What is their background? What are their distractions? Does their equipment work? Do they have the bandwidth for audio and video? And doing that conversation ahead of time is key to the success of somebody coming into a hearing where they're probably at a heightened stress and can't problem solve as easily as they could have outside of the hearing. And it's unfortunate that I have to say it, but I do have to say that as the lawyers, there's lots of comments throughout the nation about lawyers not coming to a remote hearing in the same way they would come to a in-person hearing. So one of the research tips is to speak, appear, and advocate with the same formality that you would have in the courtroom prior to COVID. Some lawyers aren't wearing jackets. So whether that was a good rule, bad rule, not a rule, it was the rule. So just to think about the way you presented in court before, and if you've made a change, why you might have done that, because the biggest complaint about remote hearings is the lack of formality around them. So we want the court to feel as if everyone in the courtroom to feel as if it is a court proceedings. And sometimes that just means a reminder but a lead from the lawyers in the room certainly assists the court in keeping the level of formality that's required and needed. I appreciate all of your accommodations and willingness to help us keep the doors open and to keep the hearings going. Most of the commissioner hearings right now are by Zoom, but you are welcome to come, and all the commissioner courtrooms are set up for those hybrid hearings. And so far working pretty well when people just aren't comfortable with the idea of maybe not having full access to a remote hearing. They can be in person, and we can accommodate that. And I'll take questions if anybody has any for me. I'll look at the chat as soon as I can do both.
Thank you, Commissioner Ressa. Judge Clark, did you have any comments that you wanted to make or anything that you wanted to say to the group?
Just two things. One, in a minute, I hope Ashley can comment upon where we're at in terms of e-filing and that process in the clerk's office, just to bring us up to speed. I know she's kept her finger on that pulse. I think it's an important topic. And secondly, there was just a question in the chat box about a virtual tour of the convention center and fairgrounds. And again, I'll ask that maybe she comment upon that in a moment. I just want to thank you, Judge Fennessy. I think your comments were spot on, and thank you for putting this together. And Commissioner Ressa, for your comments, again, very helpful to everybody to hear what we're doing. I think the overall message is we've been open and operating the whole time that this COVID crisis has been with us. And as Judge Fennessy points out, and Commissioner Ressa in her comments, we've modified our procedures substantially, but we're here to serve, and we want to be able to serve you. We do ask, as Commissioner Ressa said, for your patience. We're trying hard to get back to where we were, and that's going to take months and months. But we do want to be able to serve all of the constituents of the courthouse, not only the criminal bar, but and the family bar, but also the civil bar that needs their cases adjudicated and resolved. And I would just ask everyone, as Judge Fennessy did, to think a little bit outside the box. Talked about 6-person juries. Maybe a case could even be a non-jury trial. King County is using or doing trials completely by remote, by virtual or remote conferencing, by Zoom, if you want to say it that way, from start to finish on civil cases. And you're welcome to investigate what they're doing, and that may be a nice way for you to get your trial in and get it completed. But certainly, as Judge Fennessy points out, having parts of it by Zoom, as you can agree with counsel, would help keep people out of the courthouse, make it efficient, and get these cases out the door and resolved, which is, of course, what everybody wants to do. So just ask that you be creative and cooperative with each other as you move forward, and we'll do our best to be cooperative with you and to get these cases moved. And so I appreciate you again being here today, and I really appreciate the work Judge Fennessy and Commissioner Ressa have done today. And then if Ashley, if I could just ask you to comment upon those two things that we noted.
All right, great. And thank you to all of you for being here. It's really great to see such a good turnout. I love the idea of a tour, recording a tour of our 2 offsite courtrooms. I hadn't thought of that, so thanks for the suggestion. I certainly can do that. We do
have one. We do have one for the Fairgrounds Courthouse. We have a layout of the facility in a kind of a blueprint format from the Fairgrounds staff, and Mr. Shaw has walked through with his cell phone. So we've got video of that we can share. Anyone that wants it, let us know, and I'll try to work with Ashley to make sure that gets up on the county website.
Great, thank you. Yeah, I had forgotten that we had recorded for the bench to see. We have had trials at both locations and received really good feedback from the jurors. So I would encourage you, if you have a jury trial that is, within the next few months, I would talk to your assigned judge and let them know that you're ready to go and you would like to explore that, because not all judicial departments have done an offsite courtroom trial. So it would be nice if we also could arrange a time for you to go out there with the JA for your trial to see the layout firsthand. And then as far as the e-filing, that project is still going full speed ahead. I believe Tim Fitzgerald is still trying to get it at least off the ground in July of this year. As with anything that is this large of a change, it's important to do it right. So if there is a delay in that go live date, I'm sure that he, along with his staff, as well as me, would ask for your patience. This has been a long time coming, and I'm sure that you're all thrilled that Spokane is going to jump into this. And but we want to make sure that we're doing it correctly and really take our time to fine tune it before we flip that switch. And I'll turn it back to Judge Fennessy.
Judge
Thank
Fennessy,
you.
if you do that, can I just answer one question in the chef box? Because I think I misstated something. I want to clear it up.
Sure.
So the question, we're not limiting you to 6-person juries in the courthouse or anywhere else. It was just a suggestion to help us have more trials, because what's happened here, if I could just explain, is when we hold a 12-person jury trial in the courthouse, we have to use at least 2 courtrooms to accomplish that, because we need more space to put the juries in, to deliberate, to pick the juries, to handle that kind of crowd and or the size of group. So if we can go to 6-person juries, that's going to help us shrink the number of courtrooms that we use, ultimately allow us to do more trials. But nobody's telling you have to do a 6-person jury. And I apologize if I intimated to the contrary. So I'll just answer that one question so it's clear that what we're asking is just simply to think about it. I'll leave it there, Judge Fennessy. Thank you. Thanks for allowing me to make that comment.
Sure. And then just to try to respond to the questions that are coming across in the chat, we do not presently, at least in my courtroom, have a camera view that would show jury reactions to questions. It's anticipated, I guess, by me. I've not yet had had counsel agree. We haven't had any trials yet where the jury has been remote. In those circumstances, and I know that there are some counties that have done that if we were to get a jury that agreed to hear the case and they were all remote, that would require the court to provide connection so that the jury could hear the case from their location, wherever they are. I'm not saying that we would be opposed to that. I'm just saying we haven't had that request. We haven't had anybody be willing to move forward in that regard. And it's difficult presently to answer that question without having a few more specifics. Presently, we have had and are accommodating jury trials with jury members live in the courtroom. And to the extent that there would be jurors that would be remote, then they are visible on the gallery viewing ability for the Zoom platform. And so that's how you can observe their expressions. We also had a question about are the fairgrounds and or convention center, how's the public made aware of the location? The public is made aware of the location and the way that they would be of anything. We've tried to publicize those courtrooms. We've tried to make sure that everybody knows that they're available. If someone shows up in the courthouse and asks, then where they are directed. To the extent that they are Zoom trials, to the extent that my courtroom is out there, we try to make them available on Zoom, and my Zoom link is the same for every hearing that I have. So at any time you're bored in your office, click on my Zoom link. You can drop in and see us doing what we're doing. Usually hiding behind a mask, but so we try to maintain that, and so that we do have public and open court and in compliance, operate in compliance with that rule. I did see one of the first questions also was for Commissioner Ressa, and I'll just, before I turn it over to her, I'm going to say that the preference for our judicial officers, we're doing the best we can to try to communicate with each other and to stay on the same page. And I think we've done, to the credit of my other judicial officers in Spokane County, I think we've done a pretty darn good job. That said, there's still some personal differences. You walk into my courtroom, you will see me with a mask, other than when I'm the active speaker in the courtroom. In my courtroom, if you are an active speaker as a witness or questioning counsel, you're permitted, though not required, to take your mask off. We believe that our sound system works so that the court reporter can gather what's being said at all times. I wear my mask, as I've said, throughout the process. Other courtrooms, I think you'll find it being slightly different than that. I don't have a preference. If counsel wants to argue a motion in front of me and they want to stay in their office or they want to argue it remotely, I really do not have a preference one way or the other. You'll have to ask your individual hearing officers or judicial officers their preference in that regard. With that, I know that there may be some differences in the commissioner's docket, so I'll turn that question over to Commissioner Ressa because it was addressed to her first.
Thanks, Judge. I think the answer is the same. Is of the 7 commissioners that do family law hearings, we may each have a personal preference, but you're allowed to do both. And I don't have a preference, but what I know what we want is meaningful hearings with good records. And if that can't be accomplished remotely, then what we know we can do that in person now that we have hybrid technology in each courtroom. Technology does not work 100% of the time. And so you might have had a frustrating hearing and then 10 that go really, really well. I've had twice to tell people they are no longer allowed to show up remotely because on their behavior. Those weren't lawyers. So preference, I'm not sure is the word that I can describe for us. We just want to have meaningful hearings with effective records that allow for access to our courts in a way that doesn't further traumatize people if it doesn't have to, and that we can get our business done so that people can have the answer, especially in our courtrooms, what they need for temporary orders.
Okay, we also had a question about can the court share how many total cases have been tried to jury verdict at the fairgrounds so far? And that highlights for me the true difference between being an advocate and counsel and being a judicial officer. Because as a advocate and counsel, I certainly understand the question. As a judicial officer, I want to say no, because so many cases, the reason that we have the remote courtrooms is that you need to understand, counsel, we're prepared to go forward. And as a result of that preparation, we have a lot of cases that get resolved. Many of them get resolved between Friday and Monday. So we've had a lot of cases that were ready to go. I can't tell you, quite frankly, how many we've had go completely through to verdict at the county courthouse or at the convention center. I can tell you that from my perspective, they have been very effective in that they have encouraged cases to be resolved. My department was out at the county fairgrounds to begin a case on a Monday. That case got continued because of emergency events outside the presence or outside the control of anyone. We were ready to go with the next one. That one got settled, and we were ready to go with the third, and that one got resolved. So in that circumstance, that week, no cases got tried to verdict in the county, at the county court or at the fairgrounds. But we got 2 cases that did resolve because we had a courtroom available for them. And that's, as a judicial officer, I see that as a success because as a lawyer used to tell my clients, and as a judicial officer, I tell people, that is the control issue goes away when you turn it over to the jury or the judge. The next question on the chat room is whether or not multiple civil trials, if they're prepared to go out, how is priority determined? And again, I think that unfortunately, there's no set policy in that regard. Sometimes it depends on the complexity of the cases that are at issue. Sometimes it depends on the age of the cases that are at issue. Sometimes it depends on other factors in the particular departments. So for instance, if there were multiple trials to go out in my department next week, priority would be determined at least partially based on the fact that I'm out of town on Thursday and Friday. So if one of those cases was able to fit into a time slot, that case might get priority, but there are a lot of variables there. So I can't completely answer that question. And Judge Clark, do you have any insight or any different responses to those? And I see that Judge Zamlin is also online, so if she has anything, she can weigh in as well. She's another one of our IC judges.
I don't have anything else, Judge Fennessy. I think you hit it just right. I think that's exactly where we're at. It's kind of like the system that we ran pre-COVID, which is every department is doing their docket, and we don't necessarily interact or talk to each other about our cases. We just move forward and taking them in the priority that they are. And I think that's kind of where we're at now. We're doing a little bit more of a team process with criminal cases, but I think your description of where we're at is my understanding as well.
And I would echo that. One of the things with civil, while it may not seem civil in the traditional sense, something that is civil has, sorry, I'm on call, I gotta go. If you could hit the statutory priority of terminations.
Thank you. Yeah, so we do have certain cases that do take priority when we have those. And so as Judge Zamlin points out, we do have certain statutory obligations as judicial officers so some case in those circumstances, a termination case, for instance, might take preference over a more generic civil automobile accident case, for instance. Another question on the chat is whether or not the court has a preference at this time for civil jury trials, whether they be at the fairgrounds or the convention center or fully remote. And I've told a lot of my friends when you become a judicial officer, you get a little taller, you get a little funnier, you get a little, people have this deference that they never had before. And so that question reminds me of that. And, as Commissioner Ressa mentioned, our preference is for effective hearings. Our preference is for doing our job as judicial officers, and we don't want you to kowtow to us. That's not what we're here for. We wear our black robes because they're part of the pomp and circumstance. They're part of the formality. They're part of the reason that we don't have counsel chewing gum and sipping coffee and wearing t-shirts. We want people to recognize the formality of the process. So no, I don't think any of us is going to say we have a preference to one hearing site over the other or one methodology over the other. We want it to be the most effective it can be for you and your clients. The next question is, can we confirm that the cameras in the courtroom allow court proceedings to be viewed by the public off-site? Yes. And repeat what the cameras are, I guess what they're pointed at during trials. And again, I think that depends on each individual courtroom, but I believe that most courtrooms have a camera that you can see the witness, a camera that you can see counsel, and a camera that you can see the judicial officer. And those are then all portrayed in the Zoom format. We're all using Zoom. That then depends what view you see, depends somewhat on the view that you select as the listener or as the observer. You can click a button, I think, in the upper right-hand corner of your screen, and it says view, and you can select a gallery view, which will mean that you'll see all of the people in attendance in a particular order. You can page through those that have their video on. Sometimes you can also display only those that have video on. Those are choices that you get to make, or you can view speaker mode, and that would then toggle your screen between who's speaking from screen to screen. And if you have a two-screen system, which I do on my bench, then I can employ both. So I can have the gallery, so I can see a lot of different people, a lot of different views, and also have the speaker view running on the other screen, so that as each individual speaker comes up, I can see them more clearly in a large full screen format. Any additional questions? I remind everyone, if you haven't, on the lower part of your screen, if you take your mouse there is a chat box. You can ask a question or communicate with any one of us individually. I also, I guess, want to recognize, as Judge Clark mentioned, and as Commissioner Ressa mentioned as well, we're doing our best to try to reach out and to try to be available to problem solve. And we are very excited that we got this kind of turnout over the lunch hour from interested members of the bar. Thank you all for being here. Long time ago, there was a group on the bar. I think they called themselves the Civil Bar, a liaison committee. Rich Railier used to manage that, and they would bring things from the bar to the bench and vice versa. And as we in Spokane County Bar understand, the family law bar has been more and or less organized in that way as well. They have they approach the bench as an ad hoc liaison committee. I think that they have a more formalized group inside the Spokane County Bar Association. And so if you have, the Superior Court Liaison Committee, Mr. Wardrop just pointed out to me on the chat feature. So if you are interested in further communication or more structured communication with the bench, I think that's one way for you to structure it, is to approach the Spokane County Bar Association, talk about how you would have that formalized, who should be represented in that committee, and then how that committee would communicate with the bench, and how the bench would communicate back with that committee so that they could get it out to the bar. We have the luxury, I will say, continued luxury of having a strong bar association in Spokane County, very collegial bar association in Spokane County. And so the more we can communicate and keep those lines open, the better we are equipped to address your concerns, and the better you are equipped to address or to understand at least our limitations or our formats and how we're able to work with things. And so I know that the bench would certainly welcome a formalized, not just random contacts with every day, but certainly a structured format. I don't think I have any other issues that I need to address, but I'm certainly here and have some additional time for questions if there are any. I see that Ms. Callan had to sign off. She had another meeting to go to, and I guess I get to say that's one of the other things, that the public perception of judicial officers, we're smarter, we're taller, we're not as busy as we used to be. the reality is I'm the same size. I'm still not very funny, and I'm busier than I've ever been. So I want you guys to all to hear that from me, and I hope that you'll understand that's true of all of our judicial officers. We are not only taking care of our own cases and caseloads, our own dockets, but we're trying to participate in countywide as well as statewide committees. And so it really can be quite busy. And as Commissioner Ressa mentioned, for all of us right now, it's pretty easy to feel overwhelmed. So this community and your participation in this forum is welcomed, and we appreciate it. Thank you very much. Commissioner Ressa, any parting comments, any parting shots?
I just agree with what you just said. I know for sure I'm not taller, and as now all my children are taller than me, I feel smaller. I'm not smarter than any of you, and as my years on the bench have surpassed my years as a practicing lawyer, I don't pretend to know what it's like to practice anymore in the way that you all have to. And so your input and insight into what it's like to practice in the world we're in now, it's really important for us to understand, because my lens is from where I sit. So I won't understand yours if I don't know about it, and knowing about it is really helpful. So just what Judge Fennessy said about communicating with us in a structured way is very informative and helps us make better decisions about what our courts will look like going forward when we can really be out of this.
Thank you. Judge Clark?
Oh, thank you, Judge Fennessy, for getting this put together today. And I sure appreciate your comments about asking the bar to continue to communicate with us. So thank you for that. And thank you, Commissioner Ressa, for your time and your comments. And thanks everyone for joining us.
Thank
Thank you,
judges.
everyone. I'm going to sign off then, and I appreciate everybody being here. I think we covered all of the questions that I saw come across the chat, but that doesn't mean don't ask. Please, if you didn't get an answer to a question that you had, please reach out. Commissioner Ressa, Judge Clark, Judge Zamlin was present throughout as well, and Ms. Callan, so you can ask the question any variety of ways. Thank you, everyone.